Day 7 of the Alex Murdaugh double murder trial is continuing. We're going to go straight into the analysis for trial lawyer Carl B. Grant here to give us an overview and give us insight, Judy, on what we're hearing in court today. One of the top topics that people are asking from a push from the defense, Carl, that audio that the prosecution is claiming is a confession from Alex Murdaugh. The defense replaying that audio today, slowing it down, where it appeared to sound like, according to the prosecution, that Alex Murdaugh is confessing. Let's take a listen.
And sitting here talking today is tough. It's just so bad. It is so bad.
Carl, what we're listening to there, according to the prosecution, is Alex Murdaugh saying, "I did him so bad." The defense wants to play a slower version of that. It still appears that Alex Murdaugh is saying, "I did him so bad" in that recording. What is the strategy there from the defense slowing down that audio?
Well, because in slowing down the audio, it appears that you may hear him say, "They did him so bad." So that's what they're trying to get before the jury, that he said "they" instead of saying "I." Of course now, for the defense, if he did say, "I did him so bad," then the cross-examination should be, or the question will be, then why didn't you ask him follow-up questions? What do you mean by that? "I did him so bad." Tell me, Alex, what do you mean by that? So the investigator should have asked more probing questions to get some response to that. And also it's compelling to know that if he said that and the investigator thought that at the time, then why is that not documented in his report that he said that? Apparently there's nothing in his report that shows that he thought he said, "I did him so bad." So that's going to be the question for the jury to decide. What was the real comment? Was it "I" or was it "they"? And if it's "they" at a slower speed, the question becomes, how do you interpret when somebody talks? At their regular speed or at a slower speed?
Well, and honestly, the way the defense set up, playing the slowed down video, audio, I thought it was going to be something that was clear and compelling, but I think it left me even more confused. And it goes back to the jury being discerning, because the SLED agent tried to push back and say, well, we recorded the interview, and at that moment, we didn't have anything to challenge him on that, and suggesting that maybe pushing back and questioning him about that in that moment would have shut him down and that his attorneys were present. Another issue, Carl, this ammunition. Let me read my notes, because I got my notes. What is the significance of the fact that Maggie was killed with a .300 blackout? That's the ammunition. And that the SLED agent, Agent Croft, testified that he never worked a murder case where the victim was killed with that type of bullet until now.
That is a very powerful statement. Number one, the uniqueness of the ammunition, and the fact that this veteran agent said he has never investigated and found a person killed with that type of bullet until this particular case. So the uniqueness of the bullet, and again, the fact that where it took place, the location and everything, that is information and evidence that truly will hurt the defense.
And also the phone records. We've seen a lot of witnesses on the stand today, including someone from Verizon, where people just thought we didn't understand what he was saying or what the point of his testimony was. So why would you say there's so many witnesses that prosecution is calling up about these phone records? What are they trying to get to at this point?
This is the most boring testimony that one can ever imagine. I'm sure a lot of the jurors probably wanted to go to sleep, but I'm sure they don't want to be held in contempt of court or kicked off the jury. Well, they're trying to show that the records are indeed authentic. And so they have to go through all of these functions and make sure that everything is working properly, everything was documented properly in order to get it admitted in evidence, in order for the jury to, of course, have a key of trustworthiness about their presentation to believe that what they presented is exactly what they claim it to be.
Well, they did spend a lot of time today trying to verify the authenticity and veracity of the evidence. The defense raising some claims about the way that the phones were stored, but the judge ultimately allowing the phones into evidence, and them also stating what SLED procedures are in terms of what the defense brought up. All of this makes me wonder, Carl, when are we going to see the Snapchat evidence that we've heard so much about on Paul's phone?
That is a million-dollar question. And I think what they're doing, Judy, is they're building up to get to that. A lot of times the prosecution does not want to put the best evidence before the jury until its last act. It's like a crescendo. You're building up the case, and then you get to your strongest point, and that could be the strategy that they're using here in the presentation of their case.
And Carl, we're seeing testimony and reports out the courtroom right now that a SLED agent is testifying that Maggie Murdaugh's phone, may have been picked up by someone else who was not her shortly before her murder. The prosecution is now trying to say that may have been Alex Murdaugh picking up her phone and then calling, trying to create an alibi. How does the prosecution at this point use that evidence and then erase reasonable doubt there? Because of course the defense is saying that he wasn't there, and the prosecution was saying that he was.
The fact that it occurred, period. That, number one, after she presumably is killed at that time, at that exact moment, somebody else is picking up her phone and turning it, and you can tell that the phone went from portrait to landscape mode. That's very powerful evidence. And especially if shortly thereafter a call is coming in from the defendant, there's an argument there that he was indeed trying to create an alibi. But they have to prove that. They have to prove that. Now, the problem for all of this is the witness that testified when Mr. Harpootlian was cross-examining her, and he got her to admit that there's a reasonable possibility that there were two shooters. That's very, very important. As far as I'm concerned, that's like a metastasizing cancer to the prosecution's case, and let me tell you why. The prosecution, they've admitted that their theory of the prosecution is based upon circumstantial evidence. You remember that I told you that circumstantial evidence is the kind of evidence where you got to have everything lining up consistently to exclusively prove the guilt of the defendant to the exclusion of any other reasonable hypothesis or possibility.
Right.
Where you have the main investigator admitting on cross there's another possibility of two shooters. That's very powerful.
That is compelling. Let me ask you a technical question as we close out for today, because we're getting questions from viewers saying, now, wait a minute, you know, some of this testimony is contradicting something that Murdaugh said on a video, and they're wondering why the attorneys aren't really calling a lie, or inconsistencies at least in real time. But trial procedure doesn't necessarily allow for that. Will it be closing statements? Is that the time when attorneys will have to connect the dots to really call out inconsistencies that we've heard in testimony?
That is the time.
Okay.
Trial lawyers get two opportunities to speak directly to the jurors: in the opening statement and then in the closing arguments. And in the closing arguments, I always say the trial lawyer becomes the Baptist preacher at that time. He delivers the sermon and he's trying to close the door. So that's when that's going to take place, during the closing argument.
All right.
All right, Carl B. Grant laying it out for us, making sense of what has been yet a confusing day, but insightful day of testimony for day 7 of the Alex Murdaugh Murder Trial.